Welcome to this episode of Consortio Law Firm series, Legal Strategies Unlocked, our team in action.
It's great to be here.
Today, we're really pulling back the curtain on a genuine legal challenge that Consortio Law Firm tackled recently.
That's right.
We're going to explore the internal defense strategy, give you, our listener, a kind of front row seat to see how we handle these, well, often pretty complex legal disputes.
Exactly. And the core of this issue, it's a disagreement between our client, let's just call them Company A, and another business, Company B.
Okay.
Now, this specific matter has moved up to the appeal stage. So today, our mission is really to unpack Company A's defense arguments.
And we're focusing on a few key areas, right?
Yes. Specifically, first, whether the main point has actually been decided already by a court previously. Second, whether Company B, well, frankly, waited too long to challenge a part of their agreement. And third, the fundamental nature of the business deal between them. We're basing this whole discussion on Consortio Law Firm's internal defense memorandum.
Excellent. So let's dive right into that first point, this idea that the issue has already been decided. Company A seems to be arguing, hey, court, you've already ruled on this. Tell us more.
Absolutely. So Company A's primary argument here is, look, this appeal should be dismissed right out of the gate. Why? Because the central issue, which is whether the agreement to arbitrate is valid, well, that was effectively settled in an earlier case.
The same issue.
The same core issue. In that previous lawsuit, the court ruled that the initial case couldn't even proceed because this arbitration agreement existed. The court essentially pointed them towards arbitration back then.
Okay, so the court itself acknowledged the arbitration path already. Is there a legal term for that?
There is. It's a really important legal principle called res judicata.
Res judicata.
Yeah. It sounds fancy, but the idea is simple. The legal system needs finality. Once a court makes a final judgment on a specific issue between the same parties, that decision is binding. You can't just keep bringing up the same fight with new arguments over and over.
That makes complete sense. Otherwise, cases could go on forever.
Precisely. And this isn't just a general idea, it's actually reinforced by the specific law that governs arbitration.
Oh, so.
There's an article in the arbitration law, Article 131, that's very clear. It requires a court to dismiss a case if an arbitration agreement exists, and the defendant, the party being sued, raises this fact right at the beginning.
Right at the start, before arguing anything else.
Exactly. Before presenting any other claims or defenses about the actual dispute, if they do that, the court must step aside in favor of arbitration.
So the court doesn't really have a choice if there's a valid arbitration agreement and it's brought up correctly.
That's the strength of it. The Court of Cassation, our highest court for these matters, has really hammered this home. They've said courts have basically zero discretion to ignore a valid arbitration agreement if it's raised as a preliminary objection like this.
And if a lower court did ignore it?
Well, that would likely be seen as implicitly rejecting the arbitration agreement, which would be a major reason for a higher court to overturn that decision.
Okay, but what if, in that first case, the judge didn't write down, finding this arbitration clause is valid? Does the res judicata argument still work?
Ah, that's a really sharp question. And the answer is generally yes. Legal precedent, including rulings from the Cairo Court of Appeal, suggests that a decision dismissing a case specifically because of an arbitration clause carries the weight of res judicata on that point.
So the act of dismissing implies the clause was seen as valid enough to stop the court case.
Exactly. It prevents the party who lost that round from coming back later with a new lawsuit, trying to argue that the very same arbitration clause isn't valid after all.
That gets into tricky territory, implied rulings.
It does. Legal scholarship talks about this. A ruling doesn't always have to spell everything out explicitly to have legal force. If a certain finding is a necessary consequence, a logical prerequisite of the explicit ruling, then it's considered decided, too.
Can you give an example?
Sure. The classic example from the scholars is, if a court issues a ruling confirming that the steps taken to, say, seize property to satisfy a debt were valid, that ruling implicitly confirms the validity of the underlying debt document itself. You can't have valid enforcement without a valid underlying basis, right?
The foundation has to be solid.
Precisely. And the Court of Cassation has backed this up, stating that a final judgment carries res judicata authority regarding everything that was explicitly or necessarily implicitly decided between the parties.
So applying that here, the previous dismissal because of the arbitration clause necessarily implied the clause's validity,
right,
stopping Company B from challenging it now.
That is the crux of Consortio Law Firm's argument on the res judicata point. It's quite powerful.
And was there any pushback on whether that law, Article 131, is even constitutional? Like, does it block access to courts?
Yes, that argument has been made that it violates the fundamental right to litigation.
Mm-hmm.
But the Supreme Constitutional Court looked at this very issue. They rejected the challenge. Their reasoning was that Article 131 doesn't eliminate the right to seek legal resolution. It simply regulates it by upholding the parties' own prior agreement on how they would resolve disputes through arbitration.
So it's about enforcing the agreement they made.
Exactly. The court found it doesn't improperly diminish the right to litigation, nor does it violate principles of equality. It just directs the dispute to the agreed-upon forum.
Okay, that first argument feels pretty solid. Let's shift gears to the second pillar of the defense. This idea that Company B basically forfeited its right to challenge the clause because they waited too long within the previous case. How does that work?
Right. This is a procedural argument. Company A is saying that Company B lost the chance to argue the arbitration clause was invalid because they didn't raise that specific objection right at the beginning of the first lawsuit.
Before they started talking about the actual business disagreement.
Precisely. Before getting into the merits of the case. This relies on Article 108 of the Code of Civil Procedure.
And what does Article 108 say?
It lays down a pretty strict rule. It says that if you have certain kinds of objections, things related to procedure, like saying the court doesn't have jurisdiction, or the case should be sent somewhere else, or the paperwork is wrong, you have to raise all of them together right up front.
All at once.
All at once. And crucially, before you make any substantive claims about the case itself, or defenses, or even objections about admissibility on other grounds, if you don't follow that order,
You lose the right to bring them up later.
that's exactly it. You forfeit the right to raise those procedural objections later in the same case. It's a speak now or forever hold your peace kind of rule for these initial procedural points.
Okay, so it forces parties to put their procedural cards on the table immediately. How does this connect to the arbitration clause specifically?
Well, this is key. Article 22 of the arbitration law itself explicitly says that a challenge to the validity of an arbitration agreement is considered an objection related to jurisdiction.
Ah, so arguing the arbitration clause is invalid is one of those procedural objections covered by Article 108.
Precisely. It falls squarely into that category. It's basically saying, this court shouldn't hear this case because we agreed to arbitrate. That's fundamentally a jurisdictional objection.
Has this interpretation been confirmed by higher courts?
Yes, the Court of Cassation has emphasized how mandatory Article 108 is. They've stressed that the word before, raising objections before addressing the substance, is critical. It doesn't matter if you're arguing orally or in writing, the timing is absolute.
And what's the view among legal experts?
Legal scholars generally agree. The consensus is that the moment a defendant starts arguing the merits, making any substantive claim or defense related to the actual dispute, they are deemed to have accepted the court's jurisdiction, effectively waiving any procedural objections they hadn't already raised.
So in this situation, because Company B apparently argued about the business issues in the first case, without first challenging the arbitration clause's validity.
Consortio Law Firm argues that, according to Article 108, they forfeited their right to challenge the validity later on. They implicitly accepted the court's process by engaging with the substance first.
Okay, that adds another layer to the defense. Now let's tackle the third major argument. The statute of limitations, the time limit. Company B seems to think a 2013 amendment kept their challenge alive.
Right. Company A counters this forcefully. First, they point out that the relationship between Company A and Company B was a commercial agency, not a civil one.
Why does that distinction matter for the time limit?
Because there's a specific rule in the Civil Code, Article 382, that sometimes stops the clock on time limits between a principal and a certain kind of agent due to their close relationship. But Company A argues this rule simply doesn't apply to commercial agencies.
So that specific exception is off the table here.
That's the argument. The standard time limits for contract challenges should apply.
And what are those standard limits again?
Generally, the Civil Code gives you 3 years to claim certain types of invalidity, like if there was a mistake or duress. But for a claim that a contract is fundamentally null and void from the start, there's a longer general statute of limitations of 15 years, running from the date the contract was made. That's Articles 140 and 141.
15 years from signing. And why doesn't that special agent rule apply in commercial settings?
Because the Commercial Code, specifically Article 1661, treats commercial agency differently. It defines it as a contract for payment, and it views the commercial agent more like an ordinary creditor, not like a close representative with special ethical duties that might pause the statute of limitations in civil agency.
So the law sees them as more independent, arm's-length parties in a commercial context.
Exactly. Therefore, that ethical impediment, that reason for pausing the time limit in some civil agency cases, just isn't present here. The clock for a commercial agent versus their principal keeps ticking like any other commercial relationship.
Okay, so standard time limits apply. What else is relevant here?
Another absolutely crucial point is the principle we touched on earlier, the independence or severability of the arbitration clause. Article 23 of the arbitration law enshrines this.
Right, the idea that the agreement to arbitrate is separate from the main contract.
Exactly. It stands on its own. The Court of Cassation has called this independence a fundamental principle. They've explicitly ruled that the arbitration clause remains valid and enforceable even if the main contract gets terminated or is declared void.
So problems with the main business deal don't automatically kill the agreement to arbitrate disputes about that deal.
Correct. That's a cornerstone of modern arbitration law. And legal scholars confirm this applies to statutes of limitations too. The time limit for challenging the arbitration agreement itself is the same as for any contract. 15 years, starting from the date the arbitration agreement was signed.
Okay, let's apply that 15-year clock. When was the original contract with the arbitration clause signed?
It was signed way back in 1983.
1983. So
Yeah.
15 years from then would be 1998.
Precisely. Since Company B did not file a lawsuit specifically challenging the validity of that arbitration clause by 1998, Company A argues their right to do so now is long gone. It's time-barred.
But what about those contract amendments Company B mentioned from 2013? Didn't those
Yeah.
change things?
Company A's position is clear. No, those 2013 amendments were just that, amendments. They modified some terms of the existing 1983 agreement. They didn't create an entirely new contract.
And critically, did they mention the arbitration clause?
No, apparently they didn't address the arbitration clause specifically at all. So Company A argues these later tweaks had absolutely no effect on the start date or the running of the 15-year statute of limitations for challenging the original 1983 arbitration agreement. That clock started in 83 and ran out in 98.
That seems quite definitive if the amendments didn't touch the arbitration part. Okay, one last argument to unpack. Company B claimed the arbitration clause was somehow conditional, dependent on Company A deciding to use it.
Yes, Company A strongly refutes this idea. Company B suggested the clause was sort of dormant, maybe contingent on Company A's will, and only activated when Company A raised the objection in the first lawsuit.
That sounds unusual. What does the law actually say about when an arbitration agreement kicks in?
Article 101 of the arbitration law defines it pretty straightforwardly. It's an agreement where parties decide to refer disputes, current or future disputes, arising from their specific legal relationship to arbitration. It's an agreement made between them.
It doesn't sound like something one party can just switch on later.
Not according to the standard interpretation. The Court of Cassation describes arbitration as a voluntary agreement where the parties mutually agree to take their dispute out of the court system and give the power to decide to an arbitral tribunal instead.
It's a joint decision made up front.
That's the common understanding. And lower courts, like the Cairo Court of Appeal, have reinforced this, stating that the arbitration agreement is the sole basis for the arbitral tribunal's authority. It's what gives them jurisdiction exclusively.
The foundation again.
Exactly. And interestingly, even the Cairo Regional Center for International Commercial Arbitration, a major arbitral institution, has issued rulings confirming this. They've said an arbitration clause is effective and binding the moment it's concluded by the parties.
What if the clause uses wording like, arbitration should be pursued if necessary? Does that make it conditional?
According to a ruling from that center, no. Even that kind of language doesn't stop the clause from being legally effective from the moment it's signed. It's still a binding agreement to arbitrate if a dispute arises that necessitates resolution.
So that if necessary just refers to whether a dispute actually happens, not whether the clause itself is active.
That seems to be the interpretation. So applying all this, Company A argues their arbitration clause was a perfectly valid independent agreement that became legally binding back in 1983 when the contract was signed. It wasn't waiting for a dispute to happen or for one party to activate it.
Which means the statute of limitations clock for challenging it also started in 1983.
Correct. It wasn't dependent on some future event or condition. The 15 years began ticking immediately upon signing.
Okay, let's try and summarize the key takeaways from Consortio Law Firm's defense strategy then.
Yeah.
It seems quite layered.
It is. I'd say the main points are these. First, the arbitration agreement is its own distinct contract, effective from day one, subject to normal contract rules.
Got it. Independent and effective immediately.
Second, the time limit, the statute of limitations for challenging that arbitration agreement, starts running from the date the original contract containing it was signed.
15 years from this start date.
Third, in this specific case, well over 15 years passed between the 1983 signing and any attempt by Company B to legally challenge the clause's validity.
So the deadline was missed by a long shot.
And therefore, fourth, Company B's right to even bring this challenge now is time-barred. It's simply too late, according to the law. Added to the arguments about res judicata and waiver, it forms a comprehensive defense.
So as we've heard in this episode of Legal Strategies Unlocked, defending a client's position, especially at the appeal stage, involves weaving together different threads of law procedural rules like Article 108, fundamental principles like res judicata, the strict application of statutes of limitation, and, crucially, understanding the specific nature of the agreements involved, like the distinction here between commercial and civil agency.
Absolutely. Consortio Law Firm's defense really hinges on demonstrating that Company B's challenge to the arbitration clause is inadmissible for multiple independent reasons. It's an issue already decided, the right to object was waived procedurally, and the time limit expired long ago.
Understanding these strategies really does give you, the listener, valuable insight into how these complex legal battles are fought and hopefully resolved. We certainly hope this glimpse into our team's work has been informative.
We hope it offers a deeper appreciation for, the real intricacies of the legal landscape we navigate every day.
So, thinking about this, what parts of this multi-layered defense strategy stood out most to you? Were you surprised by the strictness of the procedural rules, or maybe the concept of the arbitration clause's independence?
And looking ahead, what other legal concepts or types of legal strategies would you be interested in hearing us unpack in future episodes of Consortio Law Firm's Legal Strategies Unlocked, our team in action?
Definitely things to think about. We encourage you to keep exploring these fascinating areas of law.